Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Good morning. Thank you so much for coming to hang out with me this morning. Today is Wednesday, February 5th of 2025, and we're still here. We're still here. We're in the Twilight Zone. We're in the upside down. We're in the Matrix. We are in the Lion, the Witch, and the Wardrobe that is Norfolk County, where women are persecuted, and they don't want you to know about it. They don't want you to know. Local Boston media is not even covering this case. Welcome to the debacle that is the Commonwealth versus Penelope McGee. I hear that this is sort of, I don't know if it's out there on Twitter. People are talking about it. I'm not on Twitter, but I'm glad that all of you are here. I'm glad that there were a lot of you here yesterday. Court TV covered it for a day or two in pieces, very sporadically. They didn't have all the testimony. They kept cutting to commercial. We tried to do that one day, and it was insufferable. We couldn't. Tony Hawk kept playing over and over and over. Law and Crime was live in the courtroom one day. That was last Thursday. And here we are on Tuesday, and it seems that everyone but us has forgotten about this case. I don't know. I don't know if anybody else is covering it, but I'm not going to shut up about it. For those of you who are not familiar with the persecution of Penelope McGee, let me give you a quick little rundown. This case goes all the way back to January of 2020. And there's a couple of wild things about this case, one of which is that the date of death for the decedent here, Andrew Savitz, is January 29th of 2020. That date may seem familiar to you because on January 29th of 2022 is the day that Officer John O'Keefe's body was found in the same county. Karen Reed is being tried by the same judge in the same courtroom as Penny McGee. Judge Cannone is on this case, and it is a bench trial. Penny McGee has opted for a bench trial instead of risking her fate to a Norfolk County jury. On January 28th of 2020, Penny McGee and Andrew Savitz had been divorced for about 6 years. They have 3 children together, and the children were living, they had shared custody, let's say. Penny had been living in a house that was owned by Andrew's brothers in a trust. Andrew has 2 brothers named Savitz who are very, very wealthy. Penelope was living in a house owned by the trust of the brothers. The brothers had evicted her from that house. They filed a court proceeding. They evicted her. She was set to move out on December 31st, New Year's Eve of 2019, but she didn't, said Jonathan Savitz, the brother who testified first in this trial. And so they gave her 3 extra days to move out. She was essentially homeless. And Andrew, her ex-husband, said, you can come and live with me. I have a room for you, but you can't stay here or be seen if Zuzi is here. Zuzi is the 18-year-old daughter. The mom and Penny and her daughter were estranged. We don't really know why. Maybe she blamed her mom for the divorce. I'm not sure. I'm not privy to that information. So Penny was living in the house. She got some sort of an email from her brother, from the brother-in-law, or she saw an email that was sent to Andrew from his brother. I'm not really sure which it is, but she had already been evicted. There seems to be some sort of confusion about that. And she was actually living in the house. She received an email, some sort of email that upset her. When she got home, she talked to Andrew about it. There was an argument. Andrew dropped dead of a heart attack in the foyer of their Brookline home. Penelope McGee is being charged with manslaughter and facing up to 20 years in prison because homicide by heart attack, manslaughter by argument. This is insane. Oh, but I also didn't tell you about his pre-existing medical conditions. That's right. Andrew Savitz had a stroke 6 months prior. He had a 90% occlusion of 2 descending coronary arteries, diabetes, and had 2 major car accidents within the 6 prior months. He had one in August of 2019 in which he totaled his car. He had another motor vehicle accident 8 days before his death. He had cognitive impairments. He had a lack of peripheral vision and many other comorbidities. The medical examiner who did the autopsy on Andrew Savitz testified, and now I have to go back to my notes to read you what she said on the autopsy report with regard to her cause of death. So give me a second because I don't want to get it wrong. Initially, she deemed the manner of death undetermined, but she then changed that about 3 months later to homicide. The cause of death in the autopsy report and on the death certificate of Andrew Savitz is cardiac dysrhythmia following an altercation in a person with hypertensive and arteriosclerotic cardiovascular disease and diabetes. Manner of death is homicide. Welcome, my friends, to Norfolk County, Massachusetts, where District Attorney Michael Morrissey will indict and try you if you upset someone during an argument. The medical examiner's testimony was wild. I suggest if you haven't listened to it, it took us 2 days. It took 2 days. It was 2 days she was on the stand. And this is what I did. The wealthy brothers donate to Morrissey's campaign. Well, I don't know, Benita, but sure somebody could find that out. Jonathan and Peter Savitz are both uber wealthy. I don't know if they both run hedge funds. I'm not really sure what they do, but they live in multi-million-dollar homes in Greenwich, and they thought it was cool to evict Penny from the house that they owned because they wanted to sell it, and yet it took them over a year to sell it. So there's that. Another interesting little tidbit: Zuzi Savitz, the daughter who testified, changed her testimony on the stand. It was clear that she hates her mother. It's clear that she wants to blame someone for her father's death. But she was interviewed by Yuri Buchanek. You may recognize his name from the Karen Reed trial of the Massachusetts State Police. And when she was interviewed by him, she said that she saw her mother shoving her father and slapping her father. And yet on the 911 tape, we heard her yelling, "Dad, stop, Dad, stop, Dad, stop." And we also heard her testify on the stand that initially, when she was upstairs, she heard the argument and thought it was her father arguing with her brother, Harry. So clear. And Penelope says in her statement that Andrew was dragging her around by the hair, slamming her up against the wall and the refrigerator and the stove. And this is self-defense. The medical examiner also testified that she reviewed the police reports in coming to her conclusions about the cause and manner of death. And even though she read Penny's statement, which indicates that she was the one being abused, she said she didn't really consider that. That because there were two people involved in the argument, and the argument must have increased his hormones, that it could be ruled a homicide, and Penny McGee could be responsible for that homicide. So there's that. I also want to point out to you, Andrew Savitz, the daughter, is represented by a man named Dan Conley. He's an attorney. If you live in Massachusetts, you may recognize his name because he was the Suffolk County DA for many, many years. Suffolk County, Massachusetts, not to be confused with Suffolk County, New York. He is also the attorney for the Savitz brothers, the wealthy ones, because Andrew was not a wealthy one. In fact, I think it was brought out that Andrew had a gambling habit. And so there's that. It was also, I got a hold of some of the divorce filings. And upon their divorce, or at least the separation agreement in 2016, Penny and Andrew owed Peter Savitz $400,000. So he had been lending them money or something. And then eventually they got a judgment against Penny. The Savitz brothers did, in the amount of something like $191,000, I think, for unpaid rent, perhaps. So there's that. And while Court TV wanted to call this the Socialite murder trial, I submit to you that Penny's not a socialite. In fact, she qualified for a public defender, and her public defender is Larry Tipton, who's an amazing attorney. Even though much of what we have been listening to is only on audio, he's doing an amazing job representing his client. He's also going to be representing Brian Walsh, so that should be a very interesting trial. And props to Larry Tipton, fighting the good fight out there at the public defender's office, working for indigent defendants who really need a good defense. He's amazing. I have the Zoom up. We're waiting. They said yesterday, she said, come back around 11. So we're waiting. I also wanted to show you, thanks, Little Cupcake, for digging this up for me, who's one of my amazing moderators, the original narrative that was spun by Michael Marcy's office. Around the time of the initial indictment, which was a year later. So the indictment didn't happen until, I think, March of 2021. So this press release from the Norfolk County DA's office, how do I get rid of this thing? Is dated March. Well, I don't know if it's dated, but March 19th of 2021. And look who the spokesperson was, David Traub. He is no longer. He has fled the coop, maybe because of the Karen Reed trial, but it was right after the Karen Reed mistrial. So we're still waiting for court, everyone. If you're just joining the Zoom, I have it up, but they didn't start it yet. They haven't been turning the camera on. It's audio only, but it's okay, because I will use my best ASMR voice. The only problem with it being audio only is that I can't pause it and I can't rewind it. And so since I find it so difficult to not speak over the audio, I'm going to whisper. Yesterday was the close of the Commonwealth's case. And the last thing that we listened to was a motion to dismiss, or a motion for a directed verdict. And I thought Larry Tipton made some very compelling arguments about why no jury would ever be able to find Penny McGee guilty. And it's going to be up to the judge to decide today whether she is going to dismiss the case or let the defense put on their case and then make her determination after the defense puts on its case. I don't know what's going to happen. I'm hoping the judge is going to do the right thing here, because this is scary. If you thought that you could be Karen Reed, think even harder, because you could be Penny McGee. Here's this. Here's the press release, March 19th, 2021. Not guilty plea in Brookline domestic violence manslaughter. So right away, they're calling it a domestic violence manslaughter. I don't know when we're going to expect. I don't know when we're going to expect a verdict. I don't know. My crystal ball is broken. Depends on how long. If she doesn't dismiss the case outright today, then the defense will put on its case. I don't know how many witnesses they have. There will be no court tomorrow because of the Karen Reed hearing. That judge Cannone is also going to listen to tomorrow. So I do not know. That's why you got to be here all the time, Nancy. You got to be here all the time because I don't know. Right away, he's spinning the narrative that this is a domestic violence manslaughter. Well, he got that right, except the one that was being violently abused was Penny McGee, not Andrew. But, let's spin the narrative right away. A Brookline woman pleaded not guilty to manslaughter at her Norfolk Superior Court arraignment on Friday, March 19th, 2021, in the January 2020 death of her ex-husband, Andrew Savitz, in his Brookline home, according to Norfolk District Attorney Michael Marcy. Assistant District Attorney Jennifer Blair asked Judge Brian Davis to impose $20,000 cash bail on Penelope McGee, 54, with a variety of conditions, including that she not leave the state without permission, remain alcohol-free with testing, and have no contact with certain parties in the case. So that's interesting. Is alcohol-free a condition of everyone's bail? This was not a drunk driving incident. There was no evidence that she was drunk, although the crime scene services team from Massachusetts State Police did show up on scene at the house where Andrew Savitz was found dead in his foyer, and they took pictures of Penny McGee's car, her Audi, which was parked outside for whatever reason. Oh, yes, you're right. It wasn't the CERT team that came. No, it was the crime scene services team, which we've learned that they actually do have for the Massachusetts State Police. You might be confused by that because in the murder of John O'Keefe, police officer John O'Keefe, the crime scene services team didn't show up on scene. They sent the CERT team, which we went over the difference between the two the other day, but the CERT team is generally responsible for things like crowd control, missing persons cases, and such things like that. One of their functions is not to collect evidence. But yet they are the team that did the grid search at something like 6 p.m. for John O'Keefe and started finding pieces of red tail light that the Canton PD did not find earlier that morning. And then Canton PD left the scene unsecured for a number of hours, and at least another foot of snow fell. And well, you know the rest of those details if you're following the Karen Reed case with me. But I'm just here to point out that 2 years earlier, exactly to the day, they did and still do have a crime services team that is supposed to come and collect the evidence. So that's another question that I have. But back to the document. Judge Davis imposed a $2,500 cash bail, $2,500 cash bail stay away orders, and ordered her to remain alcohol-free, surrender her passport, and comply with other conditions if she's released. McGee had previously entered a plea of not guilty to Brookline District Court assault charges in the incident before her February indictment. Quote, the allegations are that the defendant went to the home of her ex-husband, Andrew Savitz. All right away, I'm going to point out to you that she was living there, who was 66 at the time, on the night of January 28th of 2020, after receiving an email from his brother about evicting her from her residence. District Attorney Marcy said, well, she had already been evicted and had left that house weeks earlier. Court documents on file in Norfolk Superior Court state that the defendant and a family member who was in the home at the time give different versions of the events that followed, and that is Zuzi. The family member heard, quote, Mr. Savitz repeatedly asking Penny to leave the house. When she went downstairs to see what was going on, she saw the defendant slapping the victim in the face and chest and pushing and shoving him. She indicated that she called 911, and while she was on the phone with the dispatcher, the victim collapsed and fell to the ground, according to the Commonwealth statement of the case filed at arraignment. Mr. Savitz was transported to Beth Israel Hospital and pronounced deceased shortly after midnight. According to court documents, quote, an autopsy was performed at the Office of the Chief Medical Examiner on January 30th, 2020. Dr. Rebecca Dedrick performed the autopsy and discovered that the victim had suffered from diabetes as well as hypertensive, arteriosclerotic, and valvular cardiovascular disease. The victim had also experienced a stroke a few months prior to his incident. Given the condition of the victim's health and the facts of the incident that occurred, Dr. Dedrick opined that the cause of death was cardiac dysrhythmia following an altercation in a person with hypertensive and arteriosclerotic cardiovascular disease, and diabetes. Judge Davis ordered the defendant to return May 6th of 2021 for a pretrial conference. So right away, your district attorney, Michael Marcy, is out there spinning the narrative that this had to do with DV, insinuating that she was the one, or actually putting in Zuzie's statement, which she changed on the stand. Her testimony was that I think she saw her mother shove her father one time. We did not get to see all of Zuzie's testimony because nobody broadcast the entire thing. So, welcome to Norfolk County. The Zoom has still not started yet, and I'm hoping that they're going to turn it on and that I'm not the only one there. And that they won't turn it on, but we'll sit and wait. Thank you very much to Marie for the Venmo earlier before the stream even started, and thank you for thanking me for covering this case, and also to Justin for sending a Cash App. Thank you so very much. And here we sit. A couple of new members to welcome. Nurse, not lawyer, welcome. Cookie Harris, welcome. Wildflower 347, welcome. I think you're going to like it here. Kelly, thanks for the 5, says Melanie. You brighten my day. Thanks for being who you are. This world is a better place because you're, that's very sweet. Thank you. Thank you so much. I appreciate you, each and every one of you, more than you know. Our girl Moon Goddess was in the courtroom yesterday, boots on the ground. She went in. She told me that she gave Penny a hug, told her we're all rooting for her, and told Larry Tipton he's amazing and that he should check out the coverage. And he was also grateful that somebody is covering this case. So there's that. If you see Moon Goddess in the chat, here she is. She says the trial is insane and the lack of legacy media not covering it is crazier than anything. Tell me what you attribute that to, you guys. Where's Ted Daniel on this? Where's Christina Rex? Where's your Boston news channels? Why is nobody paying attention to another wrongful persecution of a woman in Norfolk County? Biased juror says, I listened to your coverage. Thank you for bringing this to light and sending more people to watch. Not only does this raise due process issues, but perception as an obstacle to justice. Yes, the medical examiner said that she could determine, based on, I don't know what, her psychic abilities perhaps, that Andrew Savitz perceived fear, and therefore justifying her homicide manner of death. Bev's Dizzy Glasses, thank you for gifting 5 memberships. And for those of you who are randomly gifted by YouTube, it has nothing to do with me. Congratulations and welcome. And thank Bev's Dizzy Glasses. And I love how you guys change your usernames to match the trials that we're covering. That's a reference from the Karen Reed trial because we would see her swinging in her chair and twirling her glasses around a lot. I'm going to say, if she finds Penny McGee not guilty, because she's the gatekeeper here, remember, and the fact finder, the gatekeeper and the fact finder, there's going to be some redemption, I believe, in Norfolk County. She has the opportunity to do the right thing here because this is very, very, very scary. Very scary. She said, come in around 11. I'll see you around 11. It's now 11:09. So we're still waiting. You guys wanted to know when Judge Cannone was assigned to this case. Oh, and of course, you know, this mass court website, it times me out all the time. But she's been on this case since at least 2022. We've noticed from some other cases that we were covering that oftentimes there's a different judge for every hearing. And she's been pretty much handling this case since 2022. So that's the answer to that question. Hoping, because they broke early yesterday before lunch, that she was breaking early and then coming in late so that she would have an opportunity to type up an opinion justifying her dismissal of the case. But, you know, I'm always a hopeful optimist. And I've learned that it's better than being cynical, but you never know. You just never know. Let's see. According to the docket, let's see if anything was filed today. I have so many questions about this. One of which, what is Dan Conley's involvement in all this? I don't know. I'll leave it to you to speculate because I don't have time to do all the digging that you guys do. I mean, if he was a DA in a neighboring county, here they're coming. Oh no, retry. Oh, man, what the duck? All right, hang on a second. Why did it just kick me out? Hold on. Now I gotta find my sticky. They don't want me covering this, maybe. Okay, so here's what happens. They usually give us video, like in the beginning. This is Colleen Crawford right here on the right side, bottom of your screen. Colleen Crawford, who's going to be a new expert witness in the re-persecution of Karen Reed. She's the forensics expert for the Commonwealth. In the middle, front row, is Michael McGee, coincidentally also named McGee. I'm assuming he's no relation to Penny, assistant district attorney who argued the motion yesterday. To the left of your screen in the green blazer, that's Jennifer Blair, assistant district attorney for Norfolk County. And behind Jennifer Blair in the scarf and ivory sweater is the persecuted Penelope McGee. And my heart goes out to her, just like my heart goes out to Karen Reed for she's been dealing with this for since 2021, but the death of her ex-husband since 2020. So court is supposed to start at 11. If you're ever confused about who's talking or who's testifying and they turn off the video again, I usually have it scrolling along the bottom of the screen. I know it's hard to read on your phone, but 'tis what it is. Yes, Crawford in the flesh. She's running the overhead projector and putting up the exhibits for the prosecution team. And that is Larry Tipton, who's coming and putting his jacket on the back of the chair. There's no sound up yet, so don't worry. You're not missing a thing. No, this is interesting. So, all right, put the sound on, please. God save the Commonwealth. They are getting up and saying their objection reasons in this trial. Hello, Colleen Crawford. Where's the sound? Jim, you got to put the sound on, Jim. Hello. Is anybody in there? Can they tell Jim we need sound? Come on, man. They really don't want us to hear this. But I do see there's a cameraman over here on the left side. Free Billy Tibbetts. Somebody got mad at me for saying that the other day. They said, you should know what Billy Tibbetts did before you start making jokes about him. I'm like, it's just a joke because somebody said free Billy Tibbetts once on the Zoom because they forgot to mute everyone. Same courtroom as Karen Reed, yes. Okay, there's no sound yet. Come on, man. Anybody in the courtroom? Do we have boots on the ground? Moon Goddess, are you there today? All right, Penny and her lawyer are leaving. Is Penny going to take the stand? What is happening? Yeah, today we can see, but not hear. Are they kidding me right now with this? Lip readers activate. I turned on the closed captions, but we're not getting a damn thing. Audio setting. Anybody have the speed dial to the courtroom? Maybe they just didn't start yet with the sound. Hello, Clerk Tim. Could you kindly turn the sound on the Zoom, please? Thanks, none of your business. You're welcome. Yeah, they may have forgotten to unmute the Zoom. Are you surprised, Scott? We've been doing this a long time together. Are you surprised? Ah, AJK coming in. Colleen Crawford in charge of sound. Soon it will be audio. Backwards. Well done. And from South Boston, or from SB, thanks for the 5, says, Mike McGee ran for state representative for South Boston, and Dan Conley was the DA for Suffolk County. Thank you for that. Thank you for your super chat. Okay, up and down. It's like church. Stand up, sit down, stand up, sit down. If they don't turn the sound on, I'm just going to have to make up the dialogue. But then they cut off the camera. See?
Mr. Tipton?
The defense has no witnesses, and so we rest.
No
Okay.
witnesses.
All right, so you renewed your required finding motion, the same ruling on that, and I'll hear you on closing argument.
No witnesses. Then he would testify.
We're asking you, the court, to find Ms. McGee not guilty. Quality and reliability, the credibility of the Commonwealth's case rests on 2 witnesses, Dr. Dedrick and Susie Savitz. I'll deal with Ms. Savitz in a second, but first I would briefly talk about Dr. Dedrick. Dr. Dedrick's testimony includes an absurd and unlikely proposition that if someone is attacked in a room and the attacker dies as a result of his own conduct, anger, or whatever the emotion is, caused a rush of hormones that resulted in a cardiac event, that nonetheless the presence of the second person, the victim, would result in a finding, medical examiner's finding of manner of death as homicide. It's an absurd and illogical conclusion that I think should surprise everyone. It's one that puts in jeopardy our own common sense notions of what is right and what is wrong. Government evidence started with the testimony of John Savitz. He introduced a number of exhibits that were emails and texts. Emails and texts that really tell the court nothing when it comes to what this case is all about. And what is this case all about? It really boils down to 2 things. What constitutes the precipitating event that led to the cardiac event? And second, the presence of self-defense. Those exhibits were not introduced for any basis of bad act evidence. That was the agreement of the parties. They were introduced to try to show, at least was represented, the knowledge on behalf of Ms. McGee as to the medical conditions at issue that are raised under the definition and the instruction of involuntary manslaughter, whether it's based on a theory of non-felonious battery or if it's based on a theory of wanton or reckless conduct. And that standard is what Ms. McGee knew or what she should have known. And regardless of the fact that those exhibits contain some statements that may be construed as Ms. McGee's upsetness or anger with the brother-in-laws for not being as helpful as she liked or wanted, says nothing about the proof and lack thereof of proof in this case. She went to 40 Meadowbrook Road the night this all happened because she was living there temporarily. We are talking in this case based on the evidence of a relationship between two people who have known each other 15 years, were married for 15 years, and then divorced. And when this tragedy happened, they had been divorced for 6 years. During that time, though, even after the divorce, they stayed in close proximity, 79 Randolph and 40 Meadowbrook. They had 3 children. The 3 children lived with them. The reason I say that is because I believe that the court should consider the evidence of the relationship and the fact that at times there were, in fact, arguments. And then that goes to this whole issue of verbal altercation and vigorous verbal altercation that I'll just briefly touch on in a moment. She was evicted by the trust that was controlled by one or more of the brother-in-laws. It was upsetting. There may have been some anger, but the final eviction occurred on January 3rd, 2020, over 2 weeks before this incident. But the eviction had been ongoing. And so when the Commonwealth tries to argue that anger was the driving force when Ms. McGee entered the home at 40 Meadowbrook, I'd ask the court to carefully consider all of the facts. And that's why I raised the issue of a long-standing relationship that continued even after divorce to share the responsibilities of raising 3 children and getting the older ones into college and caring for the younger ones. You know, pointing out some suggestion that the trust in evicting Ms. McGee was a terrible event or a terrible choice or showed some evidence that the trust did not care for Ms. McGee, that's not relevant to this. What is relevant is what that evidence speaks to the bias of John Savitz, the witness, and the way that he characterized some of the testimony. But he's not a major witness in this case. And this case isn't about judging Mr. Savitz and his feelings toward Ms. McGee or his pain and suffering from the death of his brother.
I'm judging him.
His bias, the question is, does his bias infect also the bias of Susie Savitz? And that is what is critical in this case. That Susie Savitz's recitation of what she thinks happened began to have differing versions from the very night it happened. She told the police at the scene a story. 3 hours later, when asked on cross-examination, she admitted that some of the things she told the police at Barrettson's house seemed to be different. She might not have admitted it different, but she acknowledged that she said some of those statements. Some of the statements she could not remember. As recently as August of 2024, she made different statements. As recent as January 22nd of this year, she made different statements. The state of the evidence is that she made different statements on the very day that she testified in this court. The fact of that is not to characterize a young woman as a liar or a bad person or anything of the sort. It is simply to set forth what the evidence shows, and it's the inconsistencies that give rise to the credibility and reliability of her recitation of facts. There is no blame to be laid at Susie Savitz for this tragedy. There's no blame to be laid at her feet for anything. She
That's classy.
decided what she thinks she saw. But it changed over time. It changed right up to the moment of trial. And what we do know is that Susie Savitz never saw what actually happened at the beginning.
It's true.
She was upstairs. What she saw was a piece of something that in the middle of what can only be described as chaos, upsetting, and a visual of her mother and father struggling. That's what she saw. And whether she's biased to the point where she would like to make her father the victim, maybe that's what she'll believe for the rest of her life. But that's not what is at issue here. It's to take into consideration for changing narrative and the fact that the Commonwealth chose to rely on that changing narrative and put her on the stand to testify. You know, in the face of these known inconsistencies and then evolving inconsistencies right up to the day, the Commonwealth continued to choose to put on this young woman in the stand. And, you know, it's not to indict the Commonwealth either. And make no mistake, anything I say in this closing argument on behalf of Ms. McGee is not to suggest that the prosecution in this case did anything corrupt or untoward or anything of the sort. As I criticize the proof, I'm criticizing the proof itself as it applies to the standard that I know this court will apply, and that is proof beyond a reasonable doubt to a moral certainty.
Really, really smart.
While I will say, honestly, on behalf of Ms. McGee, that I do not believe the prosecutors in this case were corrupt or misleading, what I do think is that they were misinformed and they were misled. By who? They were misled by Dr. Dedrick. Had there been an honest conversation, a fact-based conversation, where what came out in this trial was that the anger, the conduct, the emotional response to his own physiological reaction in the argument with Ms. McGee could have produced what we refer to as the precipitating event that led to the cardiac event. Nowhere in the documents produced, nowhere in the direct examination or the redirect examination did Dr. Dedrick admit that. That came out on cross-examination. And why is that so very important? Because it raises not just a reasonable doubt, but one of the most significant reasonable doubt issues in this case, if not the most. We heard repetitious testimony about the use of the term homicide in the context of manner of death. And for reasons that confound me, the repeated answer, the repetition was that homicide does not mean anything more than at the hand of another. But what is this case about in this so-called homicide by heart attack case? It means that the conduct leading to the cardiac event is what at issue. Who is responsible for that conduct? And the indictment, the way it reads, the way the Commonwealth presented their evidence, was that it is Ms. McGee's fault for the precipitating event. It was her conduct that caused the rush of hormones, as was testified to on direct by Dr. Dedrick. But now we know. That is not proof beyond a reasonable doubt, because in this courtroom, as in any courtroom, when you have two opposing but equally inconsistent theories, neither one can be proven beyond a reasonable doubt. And that is based on bedrock case law, and that is what the evidence is. I could go over many statements that Dr. Dedrick said that are in evidence, but I can reduce it to one set of cross-examination, questions and answers. You would agree, Dr. Dedrick, that Mr. Savitz's own anger could have been the cause of the precipitating event? Yes. You would agree, Dr. Dedrick, that it is impossible to determine whether it was his own conduct or the purported conduct of Ms. McGee that was the precipitating event. Yes, it's impossible to say. If the Commonwealth tries to argue today that there is some contributory theory, they did not elicit anything of the sort from Dr. Dedrick. And in fact, Dr. Dedrick would have answered that it's impossible to say. So that raises a significant reasonable doubt about whether any conduct of Ms. McGee on the night of January 28th of 2020 was responsible for the precipitating event. What of the injuries? They are not relevant. What we learned on direct examination, it required then no extensive cross-examination, thankfully, was that the blunt trauma injuries did not cause the death. And there was a question then, and I hope the government doesn't try to argue it, but the question is, Dr. Dedrick made it clear, I don't even know when they happened. And I don't know how they happened. If those injuries could have happened some other time, in some other setting, for some other reason, they have no relevance whatsoever to anything in this case. Dr. Dedrick admitted that these are controversial cases and they're complex cases. She agreed with me when I pointed out all of the literature that she herself testified to on cross-examination, that she relied upon, that she referred to in reaching a manner of death in a case like this. And what does that literature, some of which was admitted into evidence, but the statements of Dr. Dedrick say? It says that they are complex, they are controversial, that manner of death opinions in these cases require careful and meticulous investigation on the part of the medical examiner. Dr. Dedrick seemed to have a flawed interpretation of the exhibit of Dr. Turner's Homicide Revisited, where his first factor doesn't include the term criminal conduct of the perpetrator and aggressor, whereas Dr. Davis's article, dated 1978, clearly says that. And I think the testimony is that Dr. Dedrick seemed to believe that Dr. Turner wasn't talking about criminal activity, but in fact, when confronted on cross-examination with Dr. Turner's own words contained in that exhibit, she finally admitted on the second day of her testimony that in fact he was talking about criminal conduct. So what is the criminal conduct here? That's for the Commonwealth to argue based on what they believe the facts show. But what we know at best is a conflicting description of either few slaps, one slap, some pushing, one push. That is the state of the evidence. And even if you assume those facts to be true, it does nothing whatsoever to extinguish the reasonable doubt that is clearly established by Dr. Dedrick's admission for the first time during this trial, that anger, that emotion generated by Mr. Savitz himself could have been the precipitating event that led to the cardiac events. Dr. Dedrick's approach to this case was, in essence, to ignore the importance of the self-defense statement that Ms. McGee made to the police at the scene. In Dr. Dedrick's view, in what I can only describe as an uninformed and distorted view, self-defense means nothing in the context of manner of death and homicide because of that repetitious pounding, that homicide is a neutral term, but it's not a neutral term in this case. It implies, and in fact, Dr. Dedrick admitted that it implies that it is Miss McGee who's responsible for the precipitating event that led to the death. And now we know there is no proof of that beyond a reasonable doubt, if there's any proof at all. Imagine the slippery slope we would engage in this society, but particularly in this case, if we allow a medical examiner to ignore self-defense in reaching their opinion as to manner of death. And this is the same medical examiner who made findings of causation and manner of death without being fully informed. And then when provided with the proper information that existed before she made that particular causation finding and that particular manner of death finding and the eventual death of a state trooper, when she was provided that information, she admitted on the stand that she changed her causation and her manner of death was changed to undetermined. And what is telling about that, even though the cases are different, and I am the first to admit that, it talks about the methodology and the flawed methodology of Dr. Dedrick. And she seemed to say on cross-examination that it was somebody else's fault. Those were not words, her words, those are mine. But she said, yes, that information was not provided to me before I made my finding of manner of death. Whose responsibility is it, if it's not the medical examiner's responsibility, fully aware of a disease that end in death, and not inquire as to blood tests and inquire about the relevant literature that seemed to put in complete dispute her manner of death finding in that case, resulting in a null pros. And that goes to her methodology and the reliability and credibility of her opinion. The knowledge, what is the knowledge requirement in this case? It's this Miss McGee knew or should have known that her conduct created a significant likelihood that substantial harm could come to Mr. Savitz. So what is the evidence of knowledge? She knew he had a stroke. She took care of him. She took care of him to the degree that she got him back on his feet, or at least helped him do so. And at the time of January 28th, he was working. We know that he was driving cars and operating motor vehicles because on or around January 20th, he got into yet a second motor vehicle accident, resulting in the towing of his older son's car, Noah. What is the knowledge that we can impute to Miss McGee regarding the element in this case? That she thought that getting into a verbal argument would raise a substantial harm to Mr. Savitz? What she knew was, if you even impute what is contained in over 1,500 pages of medical records that Dr. Dedrick never bothered to look at, what you see is repeatedly references beginning in the early months of 2018 up until the end of 2019, leading to January of 2020, that his diabetes mellitus was not causing any substantial problem, but it was a significant medical condition. But there's nothing in those records, in all of the hundreds of pages of records, where any doctor who is examining and providing treatment to Mr. Savitz has told him, curb your physical activity, don't do this, don't do that, other than watch your diet. Maybe you should exercise more. The court asked for a particular citation to those 1,500 pages of medical records, and we provided those, as did the Commonwealth provided their own. But I think what's important for purposes of the state of the evidence is that it's exhibit number 4, and it's the limited production of the Newton Wellesley Hospital affiliated with Mass General Brigham that were submitted. And I will just represent to the court that the voluminous second submission of Newton Wellesley records, exhibit number 63, they contain these very same documents, but since they're in a different format, it was kind of hard to find them and to set them forth. So I will say that everything I'm about to say is contained in both sets, but I will just read. And I'm now focusing on page 11 of Exhibit 4, where there was a cardiological workup, and it was in relationship to the cerebral vascular workup that they were following Mr. Savitz on August 20th of 2019. And in the context of reviewing his physical condition, Newton Wellesley conducted this cardiology examination of his heart, a detailed examination. And what are the result findings is found on page 11 and go into page 12? That his left ventricle wall thickness and cavity size appear grossly normal. His left ventricular systolic function is normal. His right ventricular size is normal. His right ventricular systolic function is normal. His left atrium is normal. His right atrium is normal. His mitral valve has no evidence of stenosis as described, and we got the definition of stenosis from Dr. Dedrick. His tricuspid valve appears normal. His aortic valve, there's some thickening. There's no evidence of valvular aortic stenosis. There is no evidence of pericardial effusion, fluid around the heart, as the ER doctor testified to, that he saw no such evidence when he examined Mr. Savitz on January 29th of 2020. I could go through pages and pages of these 1,500 pages, and I submitted a list, and I understand as the trier of fact, the court has had occasion to look at them. There is nothing in these records that show there was any concern by multiple doctors in different situations where they did routine as well as exacting and specific examination of Mr. Savitz's heart and saw nothing truly abnormal, and that his heartbeat was normal. No evidence of heart murmur. The reason this is so important is because it goes directly to the level of knowledge and the quality of knowledge of Ms. McGee. It does nothing to put into dispute this reasonable doubt about what in fact caused precipitating event that led to the death. But since the government has a burden of proof of knowledge, we submitted and agreed to submit all of these medical records because they demonstrate, in essence, what I'll paraphrase Dr. Dedrick said on cross-examination. You could not tell whether Mr. Savitz had serious cardiac disease until you conducted your internal autopsy. I asked her, do you think you would agree? No layperson would know that he suffered from that. She ultimately agreed with me. She answered the same question when I talked about yesterday about his diabetes. She answered that same question to a lesser degree about the hypertension. What she didn't know was what the records showed. And that's that the hypertension that Mr. Savitz was experiencing, otherwise known as high blood pressure, is framed throughout these records as essential hypertension, and at least, Dr. Dedrick, agreed with me that that tends to appear in 85% of the population. And Dr. Dedrick agreed with me that people with that type of hypertension and people with diabetes can function every day in a normal environment, notwithstanding those diagnoses. And that goes to the knowledge element required that the government demonstrate beyond a reasonable doubt, because it is an element. And I think I heard the government say in their required finding argument yesterday that the standard isn't what she knew, it's what an ordinary person should know. It's an alternative. It's a subjective and an objective standard. So whether it is subjective or objective, the Commonwealth has failed to even prove that beyond a reasonable doubt. And the case I cited in my required finding memo, and I will argue it here, or I'll just reference it again, that the description of the blows, even if the court credits that testimony, the description of the blows are blows, minor blows, open hand, whether they happen 5 or 6 times, whether they happen once, they are minor blows. And what does that case say? It basically says that that seems to be some evidence of knowledge, exculpatory evidence of knowledge.
We're not aware of any time limits, Scott. They didn't turn the audio on until late in the game today.
The other thing that is so critical here is that Dr. Dedrick, for reasons that confound me, but that's not relevant. But
We're all
I hope
confounded.
that the court considers that
We're all confounded.
Dr. Dedrick ignored the very cautionary warning contained in Exhibit 67, a 2018 piece of literature where her own association, National Association of Medical Examiners, warned that medical examiners should not attempt to perceive and use perception to determine whether someone experiences fright or is frightened, or to use perception to determine the intent of the perpetrator. I had to read it to her. I had to lay it out, but it's in the record. And at the end of listening to that paragraph, after she tried to say they were only talking about that scenario 4, I pointed out that they didn't qualify
He's so good.
their statement at all. In fact, they referred to another scenario, scenario 8 also. What is the danger of that? It's because with very limited information, a medical examiner should never, using their own subjective analysis in the absence of firm foundational proof of the intent. And I'm talking about these cases. I don't care what Dr. Dedrick does in her other cases. I don't care what other medical examiners do in their other cases. I am talking about this case.
Yeah, he's so good. Strains credulity. Number 1 bailiff. Strains credulity.
I will touch briefly on the evidence that the government continued to submit, and I only touch upon it now because they raised it in the required findings, so I presume they're going to raise it here. The issue of alcohol. The issue of wine bottles in a car.
Maybe she was recycling. We talked about this.
My recollection is, Your Honor limited the introduction of the pictures of where the car was parked. And what is confusing to me is when I review the pictures of the exhibits that were submitted, and I might have them wrong, and I know it's the court's memory as well as the state of the evidence that stands, not my memory, but the photographs I've seen of the car that were introduced are the car parked in the driveway. And in fact, when the question was posed to the trooper who took the pictures on direct examination, he seemed confused about the question. But that's neither here nor there, because really what the government is trying to say was either the car, the way it was parked, or the content of the car goes to either anger or some argument about intoxication. And I suppose the government would think that there is some kind of proof that she was either under the influence, Miss McGee, and that then contributed to some kind of anger. Once again, even if it was true, it would have nothing to do. It would not affect one thing about what Dr. Dedrick admitted on cross-examination, and that it is equally consistent that it was Mr. Savitz's own conduct that led to the precipitating event. But I address it because I presume the government would. Let's talk briefly. Aside from Susie Savitz, no officer testified and no evidence came in that Miss McGee appeared angry that night. Nothing. Talk about intoxication. We're talking about a woman who has an argument with her ex-husband, and when he collapses, she administers CPR for approximately 5 minutes until first responders, and I think it was Brookline Police Officer Yanez, was the first to appear on the scene. And she is there administering for minutes. She then stands up when the first responders take over, and I believe the testimony was she stood nearby in that hallway where the tragedy occurred. And then she was told and instructed to move into the living room area only 10 or 12 feet away. And she did that. So she's following direction. And then she is approached by officers during this chaos and this yelling and this tragedy unfolding in the hallway. And she's asked questions and she gives answers. And my memory, and it's the court memory that controls, and it's the evidence that controls, is that Officer Yanez was asked on cross-examination, you don't include anything in your report about she appeared intoxicated. No, you had no reason to believe she was. As you talked to her, no. And then we had the testimony of Officer Russell. And how did he describe Miss McGee at the same period of time? He described her as first anxious and in shock. He had no evidence to believe she was under the influence. And then she's taken ultimately to the Brookline Police Station, and we heard from Officer Richards, the booking officer, and what did he say? I go through these forms when I book her. Exhibit 60, 61, 62. And one of the questions was, have you had any alcohol? And she forthrightly said yes, about 7 or 8 p.m. It's in the evidence. And then he goes through a litany of questions. And one of them that he did not check, because as he told the court there was no evidence of it, is whether she was under the influence of alcohol. And then finally, when I showed him the Brookline Police Department policies relevant to where you have an intoxicated detainee, because she was detained, did you have to implement any of those procedures? No, because she was not. So when the government stands up, if it does, and hopefully they won't, and begin to argue this, I know the court will consider all of the evidence, and I know the court doesn't need to be reminded. Conjecture and surmise and guesswork cannot be used to reach a verdict. So what did happen? First, what happened was what Ms. McGee told Officer Yanez, and it came into evidence without limitation. So it came in for its truth. And contrary to the distorted and illogical testimony of Dr. Dedrick on this singular issue, and as the instructions from the Supreme Judicial Court on the issue of self-defense as it applies to involuntary manslaughter, both on a theory of a non-felonious battery and on a theory of wanton or reckless conduct, where there is proper self-defense, the trier of fact must consider that, and where self-defense is exercised, of course, the defendant who exercised proper self-defense, regardless of what happens to the attacker, death or otherwise, the defendant is not guilty. And I think that, the court will carefully consider the evidence. And what is the evidence? It begins with the testimony of Officer Yanez, and then it is supported by the exhibits, various exhibits of the home that were admitted, and the living room area, and the kitchen area, and the kitchen, and the hallway. And they're not sequential, so it's a little difficult, but the front door is exhibit 14, and that's where she entered, where she was permitted to enter, where she had entered for quite a few days while she was allowed to stay there. Then you have exhibit 21, which is the living room wall. And in that same photograph, but also in exhibits 22, 23, 24, 25, is the living room, where the discussion began. And exhibit 39 is the picture of the couches where they were seated initially. And then we go back to exhibit 21, and as Ms. McGee explained to the police, explained is the wrong word. Ms. McGee was asked what happened, and she told the police as best she could what happened. And I asked the court to recall that during this recitation, as a response to the questions being asked, there was chaos going on about this distance, Judge, from where Ms. McGee is seated here, as described by the officers, 12 to 15 feet, was where the chaos and the tragedy was, with yelling taking place as people struggled, EMTs, Brookline Police, to address the issue of Mr. Savitz. And so she enters the house. She wants to talk about a number of things, but the thing that she recalled, or the police recalled, she said, was she was there, as they described it, as an email about the eviction that had occurred about 3 weeks earlier. And I remind the court, probably don't have to, but I will. The government says she showed up angry and full of venom. Well, how come? Because the eviction had transpired 3 weeks earlier. She was upset, perhaps. Maybe she was. But that's not what she told the police. What she told the police was, I entered and we started discussing. The discussion escalated into a verbal argument. Mr. Savitz became belligerent. He told her to get out of the house. Mr. Savitz suddenly pushed her against the living room wall. He then continued to push her into the dining room. Dishes fell. That's what she told the police. She didn't say a bowl fell. She just recalls something fell, dishes fell, and they broke on the hard tile floor. He pushed her into the refrigerator, is what she said. He grabbed her by the hair at that point. He began to push her down the hallway in an effort to get her out of the house. She struggled. He's pushing her toward the front door. And now they're near the stairwell. It's captured in the exhibits, captured in a number of exhibits. And he collapses. What does she do? She administers CPR. While this is going on, Susie Savitz has called 911. And so we have the benefit of listening to the tragedy, and I say benefit only because it is part of the evidence, and it was admitted into evidence. And what is telling about that 911? It is a terrible thing to have to listen to. But what is captured during the time leading up, Mr. Savitz collapsing, is Susie Savitz telling her father, stop, 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 stop. Seconds later, Dad, stop, stop, stop. Seconds later, Dad, Dad. And then 1 second later, she screams because her father has collapsed, telling her father to stop. Whether the inference that flows from that is that she was telling her father to stop pulling mother's hair, stop pushing mother to the door, stop pushing. That's for the court to determine, but it's a fair inference. And what is present in that 911 is nothing directed at Miss McGee specifically. There is a statement, you guys stop, but nothing otherwise. It supports the inference that what Miss McGee told the police is entirely accurate. And what happened? The government, on that issue, I just briefly talked about it. When Ms. Savitz was on the stand, they presented her with a photograph. It was confusing at first, and it confused her, but it confused me. You see anything on the floor? And so we're looking at that photograph. Ms. Savitz rightly says, I don't know what you mean, or words to that effect. And then the Commonwealth put up another photograph and said, do you see anything on the floor? And that photograph included part of the refrigerator. The refrigerator that contained pages on the front of the refrigerator. And I don't know, but it seems to me what the government wants to argue, maybe they'll argue it today, maybe they won't, but are they suggesting that since the papers remained intact on the refrigerator, that Miss McGee's recitation of what happened when she told the police that Mr. Savitz pushed her in the refrigerator, that puts her statement in dispute? Well, then why didn't they put on any evidence of how those pages were attached to the refrigerator? Why didn't they put on any evidence of how easily or how difficult it would have been for those pages to fall had someone be pushed into that refrigerator? But if the government attempts to argue that argument, I only ask the court to consider this. Why is it that the government is asking that Ms. McGee be held to some exacting and specific standard, especially given the fact that her statement was made where 15 feet away people are yelling and screaming, and she is in shock? Why do they require her to be in perfection? Why is it that the evidence shows in the photograph that right next to the refrigerator is another hard object, and that is the oven, one of those wall ovens? And so whether she was slammed into something hard and she thought it was a refrigerator or not means nothing. And why didn't the government then put on proof if they intend to argue that? And why do they hold Ms. McGee to such an exacting standard when they do not require the same standard to be applied to their witness, Susie Savitz, or their expert, Dr. Dedrick. And as we go on, what we do know is then that Ms. McGee is described as being in shock, and she doesn't leave. And what does she say in the middle of this tragedy as she is looking at her ex-husband? I have to go. I have to go with him to the hospital. Does that sound like the words of an angry person? Does that sound like somebody who doesn't care about her ex-husband? And she was told, no, you have to stay. Testimony of Officer Russell. You have to stay. So she's eventually asked to go to the Brookline Police Station, and in an uncuffed manner, she enters the back seat. He's driven there. He's taken. She's eventually hooked. She's placed in a cell. And here we are. This court knows what proof beyond a reasonable doubt is.
We
I'm
hope.
not going to pretend even recite it other than proof beyond a reasonable doubt to a moral certainty. And I know this court will apply that very high standard to the facts of this case and ultimately reaching whatever verdict this court finds. On behalf of Ms. McGee, I ask that you find her.
Thank you very much.
Well
Ms.
done.
Blair?
I can't pause this. I'm sorry. This is the prosecution Commonwealth's closing argument. It should be noted.
Look what you've done.
His closing was
Those
almost
were
an
the
hour.
words that Susie Savitz uttered to her mother, Penelope McGee, on the 911 call in the midst of her terror as her dad collapsed before her very eyes. Look what you've done. Those were the words that Susie Savitz uttered to her mother on the 911 call after she saw her mother shoving and slapping her father immediately before he collapsed. And it is this short time frame from when Susie witnessed her parents fighting to when her father, Andrew Savitz, ultimately collapsed and died that was so significant to Dr. Dedrick. I urge you, Your Honor, to recall what Dr. Dedrick told you. But for the altercation with Penelope McGee, Andrew Savitz would not have died that day. Now, the defendant, Penelope McGee, has been charged with involuntary manslaughter. And I will point out to you, Your Honor, that this is a charge that alleges an unintentional killing. There are two theories of involuntary manslaughter, the first being the unlawful killing unintentionally caused by wanton and reckless conduct, and the second being unlawful killing unintentionally caused by a battery that the defendant knew or should have known created a high degree of likelihood that substantial harm would result to another. I submit to Your Honor that the Commonwealth has presented evidence on all elements for both theories and has proven to this court both theories of involuntary manslaughter. But I would like to focus on the wanton and reckless theory right now. To find the defendant guilty of an unlawful killing unintentionally caused by wanton and reckless conduct, the Commonwealth must prove four things beyond a reasonable doubt: that the defendant caused the victim's death, that the defendant intended the conduct that caused the victim's death, that the conduct was wanton or reckless, and that the defendant did not act in proper self-defense. I submit to you, Your Honor, that the Commonwealth has given you everything you need throughout this trial to find Ms. McGee guilty of involuntary manslaughter under this theory. I'd like to address the first element, that the defendant caused the death of Andrew Savitz. How do we know this? Well, you heard the opinion of Dr. Dedrick, a well-qualified medical examiner. She told you she had performed over 3,000 post-mortem exams. Board certified. She's been qualified numerous times as an expert in court. She told you that she used her own experience, her training, her observations and information contained from medical records and 2 different police reports to reach her opinion. And I will remind you that Dr. Dedrick opined that the cause of death was cardiac dysrhythmia following an altercation in a person with hypertensive and atherosclerotic cardiovascular disease and diabetes mellitus.
Oh, we know, girl. We know.
Dr. Dedrick also opined that the manner was homicide, a classification that was permitted by the name guidelines, and she told you that that was a medical definition, not a legal term. Again, Dr. Dedrick told you, but for this altercation with Penelope McGee, Andrew Savitz would not have died that night. Dr. Dedrick also told you that a significant factor in her opinion was the timing of the sequence of events. And I submit to you, Your Honor, that the timing of the sequence of events is also important in the legal causation of Mr. Savitz's death. I urge you to consider the timeline that you heard from when Lizzie Savitz called 911 and the testimony of the paramedic, Kevin Robichaud, and then the testimony of Dr. Olufadeji. Lizzie was on the phone when Mr. Savitz collapsed. She told you as she was calling 911, she could see her mother shoving her father in the chest multiple times and slapping him. And while that call was in progress, a 4-minute call, a little more than 4 minutes long, during that 4 minutes, she saw them arguing. She witnessed the shoving and the slap. Her father collapsed. And then you heard the paramedic tell you that they were dispatched at 11:08. They were at the scene at 11:09. They were at the patient at 11:10. They were at the hospital by 11:43, and then the time of death was called at 12:14. A very close in time, important sequence of events. Your Honor, Dr. Dedrick also told you about what ill health Mr. Savitz was in. She noticed a number of cardiovascular injuries, including a 90% stenosis of the carotid artery, diabetes, and other indications of severe cardiovascular disease. However, Dr. Dedrick did not classify this as a natural death. You heard evidence of Penelope McGee arguing with Mr. Savitz, yelling at him, acting frantic, angry, erratic, according to her daughter.
Lizzie thought she was fighting with Harry.
So enraged that she pushes and shoves him multiple times and slaps him in the face. That escalating behavior, Your Honor, is what I submit to you Dr. Dedrick was referring to when she told you about the flood of hormones, the fight or flight response, the misfiring of his heart that she described. Penny McGee was right there when he collapsed. There was no break in that sequence of events. Andrew Savitz never recovered. Therefore, Your Honor, I submit to you that Penny Savitz was the cause of Andrew Savitz's death. Now I'll move on to the second element.
Oh, I thought she was
which is
done.
that the defendant intended the conduct that caused the victim's death. Now, how do we know this, Your Honor? Nothing you have heard over the course of this trial, I would submit to you, suggested that any of Ms. McGee's actions were an accident. Penny McGee intentionally went over to the house that night. She drove herself there. She was angry about the eviction process.
She was living
there
there.
to confront him.
She was living there.
Recall the description of Ms. McGee's behavior by her daughter, Zoe. She was frantic, erratic, angry. And when she saw them arguing, recall the description of what Zoe said was happening. Penny was pushing back to him. She was shoving him. Penny was shoving his chest with her hands. Her hands touched his face. She slapped him once. And he had his hand up in kind of a defense. I ask you, Your Honor, do those sound like accidental touchings or unintentional touchings to you? I submit that they were the intentional actions of a furious woman who had had a little bit of wine earlier in the evening,
How do you
who
know?
had
There's no
already been
evidence of
evicted
that.
from one house and who was being asked to leave another.
Guys, check the poll. Take
Now,
the poll if you
third
haven't.
element, the defendant defendant's conduct was wanton and reckless. Wanton and reckless conduct, Your Honor, is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or disregard of the consequences of such conduct. Think of the disregard Penelope McGee had for Andrew Savitz as he went to his house angry, confronting him with that email.
She had a mini pint of wine.
Again,
Sonia.
she was yelling, frantic, erratic. She consumed alcohol. According to Zoogie, she was stumbling, she was slurring her words, and the argument became so heated, the discussion escalated into an argument, according to Penelope, that a large ceramic bowl broke in the kitchen. Despite that fact, Your Honor, despite the fact that Penelope knew that Andrew had a series of serious health conditions, she engaged in this erratic behavior. She argued with Andrew Savitz until she had him in the hallway and was physically attacking him. This is behavior that I would suggest to Your Honor is exactly the type of behavior that would pose a grave risk of harm to a person who was in the fragile state that Mr. Andrew Savitz was in. Your Honor, I suggest that a reasonable person would have known, and Penelope McGee should have known, that physically attacking a 66-year-old man who was experiencing cognitive issues, wore a glucose monitor for his diabetes, had suffered a stroke 6 months ago, had a 90% blockage in his carotid artery,
Which she didn't know, and it's carotid.
Had been in a car accident just 6 days before, would have created a high likelihood that substantial harm would result to him. I submit to Your Honor that these actions were taken by Penelope McGee with an utter indifference to their consequences. Why should Ms. McGee have known that her actions would have caused a grave risk of harm to Mr. Savitz? She had plenty of knowledge of all of these conditions and the ill health that she was in. And the court has seen multiple items of evidence to suggest this fact. She was aware of the seriousness of his health conditions. She was his primary caretaker after the stroke. She helped him recover from his first car accident in August of 2019.
But she wanted him
She
dead.
knew about the blockage in his
She had nothing
carotid
to
artery
gain.
and the looming possibility of vascular surgery.
If
She
she's
was the one that was updating his brothers about his status and what the doctors were saying. She took him to his doctor's appointment. She was his healthcare proxy. You have evidence before you that she was very active in his medical care and his planning. And I would draw your attention, Your Honor, to the medical records from the Newton Wellesley Hospital from August of 2019, specifically pages 148 through 178. In those pages, Your Honor, you will see that there are several notes to Ms. McGee being at his bedside, talking to the doctor. The nurse's notes indicate that ex-wife was on page 171. Ex-wife was updated. Ex-wife will assist with the discharge plan.
she was taking care of him when nobody else
In
would.
those medical records was the discussion of the stenosis in his carotid artery and the possibility of the vascular surgery. And in fact, both Mr. Savitz and Ms. McGee were updated that he was to do a follow-up in 4 to 6 weeks to consult with vascular surgery. There's also discussion in those pages, Your Honor, of the medication for diabetes and high blood pressure and depression.
If she says carotid instead of carotid one more time, my head's going to
Your Honor,
pop
I would
off.
also draw your attention to exhibit number 10. Ms. Crawford, could you please see exhibit number 10?
Exactly. Carotid. If you don't even know what you're arguing, then you should just take a step back.
On the yellow
And this should
paragraph.
be over. It's the carotid
Your Honor, I
artery.
would draw your attention to this exhibit and specifically the text message from Penny Savitz from August 24th of 2019 after he had gotten out of the hospital, informing his brothers on the update of his health and the various conditions, including that he has a clogged left carotid artery, may require vascular surgery, but not urgent at this point. And I would, again, draw your attention to the medical records where it indicates to do a follow-up 4 to 6 weeks after that. Your Honor, this exhibit, this text message to John Savitz shows, Your Honor, that Ms. McGee was part of the medical care and planning. She was retaining that information. She had an understanding of his medical conditions, and she was reiterating it to his brother.
I can't even.
And the defense has argued to you, Your Honor, that that was back in August. And how would Ms. McGee know that he was in such ill health moving ahead to January? I think he indicated that she had nursed him back to health by the time this incident happened. But I would suggest to Your Honor that the evidence is quite contrary. We could please see exhibit number 11, Ms. Crawford.
Final call on the poll. Would
Your Honor,
if it
in
was you,
exhibit
bench
number
trial
11,
with Cannone or
January
jury trial
22nd,
in Norfolk?
2020. Only 6 days before Mr. Savitz passes away. Mr. Savitz had his second car accident, another serious one. And in this text message at 1:57 p.m., at the bottom of this paragraph, Ms. McGee indicates that she doesn't think Andy can live alone or take care of Harris. We need a better alternative.
The brothers wouldn't pay for an aide, and they're like
If Ms. McGee
billionaires.
had thought that Mr. Savitz was nursed back to health by January of 2020, why would she be suggesting to her brother that he could not live alone? It indicates further back in this paragraph that her son
They should have
Noah
paid to take care of their
called her
brother.
and asked her when his father's going to die. Your Honor, I would submit to you this was not a person that had been nursed back to health, but was still suffering from many of these serious health issues that had been ongoing for several months that Ms. McGee was well aware of. Now, Your Honor, defense talks of the inconsistent statements of Zoe Savitz.
Yeah.
I would submit to you, Your Honor, Zoe Savitz was very clear in all of her statements that there was some physical attack by her mother upon her father. She told you on the stand he was pushed and shoved multiple times and slapped once. Your Honor, the 911 call is very telling that Zoe Savitz just saw her mother do this to her father. It is true. You hear in the call, guys, stop, stop, dad, stop, stop, dad. But what you also hear, Your Honor, is just after Mr. Savitz collapses, Zoe utters to her mother, "Look what you've done." And I'd like to play that section for you, Honor, so that, Your Honor, so that you can
She would have said,
isolate it out so you can hear it. Ms. Crawford, could we please
look
play
what
clip
you've done,
number
because
1?
she hated her mother for whatever reason. We saw that on the stand. That's why I would go for the bench trial.
You hear, Your Honor, the dispatcher asks if he's breathing. Zoe says he's breathing. The dispatcher says he's breathing, and right after that, Your Honor, Zoe says, "Look what you've done." Ms. Crawford, could we please play clip number 2?
Right. We hear it. Look what you've done.
Your Honor,
Carotid
I
artery.
ask you to credit the statement of Zoe Savitz about what she had witnessed during that 911 call.
Kind of like Karen took her shoes off.
Again,
Didn't
she
take her
told
shoes
you
off, so
saw
she
her
must be
mother
guilty.
shoving and slapping. And she looks at her mother and says, "Look what you've done." I would suggest to you, Your Honor, that that is an excited utterance made after an extremely exciting terrifying event that should be credited.
An excited utterance by someone other than the
Now I'd
defendant?
like to turn to the fourth element, Your Honor, and that is that the defendant did not
The
act
daughter
in
said it,
proper
yeah.
self-defense. The Commonwealth must prove that the defendant did not act in proper self-defense. And I submit to you, Your Honor, that the
They saying that
defendant
Penny said
did
it?
not use all reasonable means of escape to escape the physical, of retreat to escape the physical combat. The law requires that a person must retreat unless it's not reasonably safe to do so. Your Honor, Penny McGee did not retreat, and the evidence that you have seen before you shows that she reasonably could have. Ms. McGee was not welcomed in the house of Mr. Savitz as that argument progressed. You heard from Zuzi that her father was trying to get her mother to leave.
Now she's
You
arguing
heard
duty
from
to retreat?
Officer Yanez that even Ms. McGee said that Andrew Savitz was trying to get her to leave that house.
She didn't duck and kill him.
There was nothing stopping Ms. McGee from leaving, Your Honor. There were two doors that were reasonably close to one another. Her car was parked outside. She was being asked numerous times to leave. Ms. McGee could have just left. She did not have to push him. She did not have to slap him. She did not retreat before using the physical combat that ultimately resulted in a flood of hormones that caused Mr. Savitz's collapse and his ultimate death. In conclusion, Your Honor, I would just remind the court, as the court, I know the court is extremely familiar with the standard of reasonable death.
Please rule from
And
the
that it
bench,
is not
please.
proof beyond all possible death. Because everything in our lives is subject to some possible death. But if you have in your mind an abiding conviction to a moral certainty that the charge is true, then this is the proof that you need. I submit to Your Honor that the Commonwealth throughout this trial has given you the proof that you need. The testimony of John Savitz, the testimony of Zuzi Savitz, the very qualified paramedic, the emergency room doctor, and Dr. Dedrick, the medical examiner. That coupled with the medical records and the text messages and the emails, I am confident, Your Honor, that when you consider all of the evidence that was put before you, that you will find the defendant, Penelope McGee, guilty as charged. Thank you.
All right.
Please
Thank you
decide
very
today.
much. So I don't need to recess to deliberate. I just want counsel to know, Ms. McGee to know, and the record to be clear that I have gone through all the
We have
exhibits.
we're going to have
We
a
were
verdict.
half days last week. Friday afternoon, I got to go through most of the exhibits. Mr. McDermott was kind enough to help
She's
me
ready.
get together the
I'm
medical
nervous.
records. I went through them this weekend, and we had last night and this morning to review everything that was admitted this week. So I've gone through everything. Ms. McGee, would you stand, please?
Oh, I'm so nervous.
On
my God.
manslaughter regarding, on the theory of wanton and reckless conduct, I find you not guilty. And manslaughter caused by a battery, I find you not guilty.
Not guilty!
Ms. McGee, you're discharged unless held in other process. There being no other process, you're hereby discharged. Thank you.
Thank you very much.
What? Not guilty. I didn't even have time to put the poll up. And we don't have any audio. I mean, we don't have any video. Oh my God. Oh my, oh my God. I just want to cry. Oh my God. Judge Cannone has just declared Penelope McGee not guilty on all charges. I am stunned. She is redeemed. Praise be for doing the right thing. She didn't even need to take a break. She didn't even need to take a recess. Nothing. Is anybody going to broadcast this? Is anybody going to show us the actual video? Penny is free. They are not going to turn on Zoom video, but holy, this is the trifecta. This is the trifecta, my friends. We saw in acquittals. This is the third. Brian Camp, Hampshire County, not guilty. Daniel Penny, not guilty. And now Penny McGee, not guilty. What a day for justice. What a day for Norfolk County. Holy duckin' mother. I'm not crying. You're crying. I'm not crying. You're crying. Praise be. Praise be. Judge Cannone has declared that Penny McGee is not guilty. It's a great day. Shout it from the rooftops. I don't even think anybody's in court today. Moon Goddess was there yesterday. And not guilty on all charges. You have no idea how happy it makes me to type that banner out. She had zero hesitation. She reviewed everything. Judge Cannone has proven that she can be fair and that she gets it. And this was the results of the poll. I asked you, if you were Penny McGee, would you choose to risk it with a Norfolk County jury, or would you choose to risk it with a bench trial of Judge Cannone? I personally said I would go with the bench trial because I thought that the jury may have a lot of sympathy for Zuzzy, and they may not have understood the medical examiner, and they may have thought that because the medical examiner is a doctor, that therefore her testimony should be, like God. And we saw that the defense had no witnesses. I know they had an expert witness because they said they had her there the other day. And so we know they had an expert. They chose not to put the expert up. They chose not to put Penny up. Somebody said earlier that they were wondering why the judge didn't give Penny a colloquy about testifying. And I think that's why we saw, because we're at the beginning of that Zoom, the video was on, and we saw Penny and Larry Tipton walk around. It looked like they were on the bench. She may have done it then off camera without the audio on. So that may have happened. And I voted bench trial, but 74% of you said you would have risked it with a Norfolk County jury, and only 26% of you said that you would risk a bench trial with Judge Cannone. And wow, just wow. I'm going to go to Super Chats now, and please, thank you, Attorney Wannabe, for your super sticker. Cookie Harris, thanks for the 10. For some reason, I had to rejoin. Didn't know I'd left, but so happy to be back. PSA, if you change your YouTube premium payment method ever, make sure memberships aren't impacted. Thank you. Ghost of John O'Keefe coming in here with $50 and says, what a tragedy. If they don't broadcast it, it's hard to put her pretty face with the persecution. I hope the judge does the right thing here. Thank you for all you do, Melanie. She did it. She did the right thing here. And it is my feeling that this was really have been a crapshoot with a jury. I wonder if the brothers were in court and what their faces look like. And what a great day. And from SB said, Mike McGee ran for state rep for South Boston. Dan Conley was the DA for Suffolk County. Thank you for pointing that out. And for your 5, Adam Handful, I believe he doesn't want to open any doors with witness testimony. This will leave Bev no choice but to dismiss this. Just my opinion. Adam, you were on the money with the 10. You were on the money. You were right. She reviewed everything over the weekend. She was prepared. She knew the facts better. So here's another thing. I noticed some misstatements in the ADA's closing. And I'm thinking, a jury might not pick it up. They're forced to take notes. They may not have picked up the discrepancies. They may take what the ADA says for truth. And the judge knows the facts, just like we knew the facts, because we've watched every minute of testimony that we could get our hands on at this trial. So we knew that when she was saying certain things in her closing, they were not accurate. And I think the judge knew it too. Thank you, Tracy. This is moot now, but she wanted to know if the judge had to rule from the bench. No, because the jury would take time to deliberate. So she could have deliberated, but she said, I don't even need a break. I've reviewed everything. I'm ready to make my decision. And she was not guilty, not guilty. Thank you. You're free to go. Goodbye. Your 5-year nightmare is over, Penny McGee. And I could not be happier. Bev's Disney Glasses, thank you for tuning in from Canada, for saying I'm your favorite to cover trials. Your snark is on point. Sometimes I have the exact same reaction as you with the same snark. Keep it, my snarky friend. A lot of people say that I just say what they're thinking because I really have no filter. I try, but at least with the curse words, I try. Texas Prime, thanks to 10. I just can't get to any criminal act with her actions. It's one thing to inject someone with propofol knowing it's dangerous, but how could she have known he would die? Yes. Oh, yes. Oh, yes. And Judge Cannone saw it. She's no dummy. I mean, you may think that she's unfair to Karen Reed, or it seems like she's unfair to Karen Reed, and that the defense had a lot more motions denied during the first debacle, but it seems like she's been ruling in the defense's favor so far as these pre-trial, retrial motions are concerned. So perhaps we will see a whole new Judge Cannone in the re-persecution of Karen Reed, which is scheduled to start April Fool's Day. And we have a hearing on that tomorrow. We will be covering that live at 9, a motions hearing. Maybe it's a whole new Bev. Irish Wolfhound Mama is watching from Ireland and is saying this is a great closing from Tipton. Thank you so much for your super chat. Duncan, Judge Cannone has a chance to make a really easy decision and reveal that she can actually be reasonable and there's a limit to her bias toward the state. And I think we saw that. You were right. You called it. Number one bailiff. I can't believe this trial's gotten this far. Bev amazes me again. Thank you for your 5. Dennis the Menace has 100+ empty beer cans in his car. Do not get pulled over in Norfolk County and get those to recycling. Go get your money back if you guys have a deposit on cans and bottles. I don't know. Texas Prime, if he was sitting on that much of a time bomb with his heart, then he should have been in a hospital. Could it be his own doctor did not know the severity? Yeah. And if she said cartoid instead of carotid one more time, my head was going to pop off. Luckily, we didn't have to listen to that too many more times. But learn the pronunciations of basic medicine if you're going to be arguing that, especially if you're going to be arguing that. And if you've never, have you never even watched like one episode of Quincy? I wanted to say Quincy because, you know, Massachusetts, Quincy or Law and Order or any other like autopsy type show where they talk about carotid arteries all the time. Lori Lake from Canada, how about a pacemaker, an angiotomy, anything that involves a scope or follow-up? Thank you for your super chat. She's been given more time for closing than Karen Reed. That is right. They had defense's closing was at least 45 minutes, closer to an hour. I think they need more time to close on Karen Reed for sure. Charlie Lynn, I second the previous commenter. Would you consider having Attorney Tipton on your show? 100%. Mr. Tipton, please. Penny McGee, come on. We want to talk to you, Penny. We want to congratulate you. We want to pop some champagne in your honor. Dennis the Menace said Dedrick should be disciplined for malpractice. Just ducking around reminds me of Carly's prosecutor cringe. Christine, Melanie, if Cannone finds her guilty, is she going to get bad press for this? We don't have to worry about that, Christine, but thanks for your super chat. I'm a little late on these. What the fudge are they putting in the water at Norfolk County DA's office? Another nonsense case, but justice was served in Norfolk County today, my friends. Justice was served. Ron Handy says, yay! With a 5. Thanks for your super chat. Don't duck with lawyers and nurses. We know stupid, says Lori Lake from Canada. Thanks again. Dennis the Menace voted bench. Duncan, Idaho says even Judge Cannone has a limit. Moon Goddess says maybe you can get Penny and the attorney to come on your show. We're going to try. Thanks, Ty Phony, and thanks for your super chat and for being in court yesterday, Moon Goddess. Thank you for being boots on the ground in court, showing Penny support, because there were not a lot of people in that courtroom at all. And we knew, you guys knew, the Cupcakes knew that Penny McGee needed support, and this case needed exposure and telling. And it's unfortunate that nobody covered it because they didn't get to celebrate with us. So nanny poo-poo on you. Yeah, let's do it. Yes, Judge Bev came through, says T Phony. Judges understand nuance, says Marissa with a 5, 100%. Wow, says Wildflower 347. Her lawyer's amazing too. Larry Tipton, he is a public defender. Best free lawyer I've ever seen. True Crime Addict says, my faith has been restored. Hallelujah. Has been with me for 7 months. I thank you so much. Sherry Mix says there will be a job posting for medical examiner soon. Thanks for your super chat. Emma is here from Ireland. Love to hear what Dedrick has to say now. Thank you, Melanie, for bringing us this trial. 20th Century Fox says, Miss Penny, you are all set. Thanks for being here with me for 5 months. Court TV right now. Oh, come on, really? Hold on. Oh, they've got it. Hold on. But you know what? We cannot. Hold on. Let me get it. We can't rewind on this. We can't. There's Penny.
And Penny McGee's daughter, who said she saw her shoving her father into the wall, but this judge, and she took a chance on this, she didn't have a jury, Judge Beverly Cannone, finding that that was not sufficient to find her guilty of manslaughter. Let's bring in civil rights attorney and trial attorney Adante Pointer, who is standing by. Adante, this was one of those cases that was very legally nuanced. Do you think it was the right decision? Obviously it was, but she took a chance with having this with the judge.
Certainly, I think she did. She made an excellent decision as it relates to having a bench trial in a situation like this, where someone obviously passed away and lost their life, and that can, as we've discussed and see.
All right, you're here for
in
my
real
commentary,
time.
not his, but I'm going to leave this up in case they show any more from the courthouse footage. Tipton has his own law firm for murder charges. The Commonwealth hires defense attorneys for public defender. That's great to know, KPC. Thank you, because that's what we do here on Long Island as well. And that is why the Long Island serial killer has private defense attorney, Michael Browning, who is also excellent.
Versus being driven by the
There's more
fact that
footage of
someone
Penny.
lost
Come
their
on back
life.
to your screen.
And so this lady, this former defendant, now acquitted woman, made an excellent choice as it relates to having a bench trial versus going with a jury.
And that was her
I
reaction.
had a lot of questions in this
to the not
case.
guilty.
The fact that it was charged in the first place. I do think if she was found guilty, it would have not set the best precedent for future cases, because I was wondering what was going on with Mr. Savitz's that day before she came over to the house. What were, maybe he had some business dealings that day. I have no idea what was going on. Those were some unanswered questions here. But then she comes over, they get into an argument, and then he ends up dying. And so it was as if you knew that the person that you're arguing with had health conditions, you can't raise your voice at that
Look at those
person.
hugs.
You can't get into an
Oh
argument
my.
with this person.
Moon
It's a
Goddess said
tragedy
that's
that
her
he
son.
lost
Moon
his
Goddess
life.
was in court yesterday.
There is no
She knows.
question. But to find someone guilty and to spend 20 years behind bars because she gets a notice that she's going to be evicted and then comes over to the home.
No, she had already been evicted. Get the facts right if you're going to cover the case. Thanks, though.
Evicted. I just thought it was going to send a bad precedent if the judge found her guilty.
Oh, look at her face.
Agreed. I totally
And
agree
look at her
with that.
hugging her
The
lawyer.
idea that a person could
Oh, I
be held
can't even.
responsible for someone's death because that person has some
Oh my God.
pre-existing medical conditions, and you
I can't. They
engage
don't
with
even
this
get the
person,
facts
and
right. They don't
although
even,
this
I'm
was
muting him. They don't.
somewhat-
She did not just get an eviction notice. She had been evicted. She had moved out on the 3rd of January. This happened on the 28th into the 29th. Thank you for telling me. Here, come back to your screen.
precipitated the heart attack. This is some pushing and shoving, and you're right. The precedent that would set, we would all be on notice that, hey, if you know someone is what we call in the law an eggshell plaintiff or an eggshell type of person with a very thin skull, and you just flick them in the head and they're dead. You would be on the
Eggshell
hook
plaintiff
for
is
any number of people.
civil, a standard in civil cases. But here you see Penny talking to her friends in the back row and her lawyer and her son. And this is a great day. What a great day. Lady Zelda says, I chose bench trial because the judge understands the repercussions this could have on a very wide scale if Penny was found guilty. Yes, Court TV showed the verdict, crying, so happy, says Taylor. Thank you. Hopefully they'll play it again. Terry Sue, thanks for the 20. My faith in the Commonwealth has temporarily been restored. So happy for Penny. Thank you so much for the 20. I'm just a girl in the world. Thank you for your 20. Says, thanks for covering this case. Thanks you guys for watching and for being interested in this case because nobody else was here.
Determination by the medical
Show the
examiner.
verdict
She even
again.
put the manner of death as homicide, meaning caused by another person.
talk over
and
it.
not a legal definition of homicide. The judge had to make the ruling on that. Dante, they didn't put on, as far as the defense, any
Thank you. I'm just a
witnesses.
girl in the world.
And that's a big decision to make as well. You roll the dice with getting a bench trial.
Bars
but then to
dump.
not
Thank you.
even
Says golf
bring
clap for
on
Bev.
any experts, which they did have one in the
Play
wings. We know Dr.
Judge
Priya
Cannone
Banerjee,
reading the
who
verdict
was
again,
our Court
please.
TV analyst, forensic pathologist, and
Golf clap
also
for
was
Bev, says
on the
Forrest
stand
Dump.
in the Natalie Cochran case that we just
On fire
covered.
24.
But real
Maybe
quick,
Karen
your
should call
thoughts
Tipton.
on,
Bev likes
their decision
a
not
public
to
defender.
put on a case.
He's Jackson.
Clearly, the
She was a
defense
public
thought
defender,
that they
Bev was.
need
You're
to put on
correct,
a case
Judge
or a
Cannone.
witness, and they got the information and/or the reasonable doubt from.
What the duck? Thanks for your 5. Seeing that Auntie Bev does in fact have the ability to be reasonable and unbiased actually makes me even more angry about Karen. Well, let's see what happens. Let's see what happens. Listen, if somebody said they would pick a jury because they would expect one juror to be reasonable, but that's the problem. Then you have a mistrial. Then you're in the position where you have to do this again. And it wouldn't have ended for Penny today if there was a mistrial. So I don't know. I mean, look, hindsight's 20/20, but I thought, and I've said this from the beginning, that she was making a smart decision in this particular case to go with the bench trial. Lori, thank you for thanking me and also for your super chat. Good citizen. I hope this gives fuel to the FBI to investigate the MSP and the DA. Says good citizen. We're going to put this small for a minute. If they come back and let us see the actual live verdict, that would be amazing. But you know, who knows if they will. Thank you for your super chat, good citizen. I know you're a local. Rassler's mom says, I'm crying. Bev deserves respect after this. I'm so happy. Thank you for being with me for 10 months, hanging in there for all the tough things that we cover. K-Wags, thank you for the compliment. She says, I'm shocked. Justice in Norfolk. See if they're we're gonna have to watch Tony Hawk again. Who knew it was possible? Thank you, Just Cannone. Let's keep it up. You think Boston 25 will cover this now? Do you think Ted Daniel and Christina Rex will cover this trial now? You think now they'll talk about it now that it's over? Nobody gave a duck about it while it was going on, or they were told to stay away from it. I'm not sure which. But they had the opportunity to cover Judge Cannone's very fair and accurate coverage of this trial, and they didn't take it. Susie says, I got the feeling that Cannone was seeing through Spanky the other day. He pushed his luck, and I hope I'm right. It stays that way. Thanks for your 5. Brooke W., thank you for your super sticker. CB's SW2, thanks for your 5. Tipton saying in open court that Bev told him not to object was when she decided to not be in trouble. I don't remember hearing that, but you know what? I was writing notes and talking over it. And so I may have missed that, but I don't remember him saying that. How are you guys feeling? Wow. Thank you for watching. Thank you all for watching. Thank you all for being the ears on this channel when I want to shout from the rooftops for people who are being persecuted unfairly. Thank you, Mama She, for your Cash App. And thank you, Sherilyn, for your Cash App. You guys are amazing. Justin, I thanked you earlier, I believe. You guys are amazing. And Mama She says, oh, wow. Wow. Oh, wow. Bev did right. Sherilyn says, I'm not crying. You're crying. Stop. Stop. Justin said earlier today, before the stream even started, would love to see Judge Cannone throw the case out. You right, Justin. You right. That is what happened. That's what we saw. Allie, thanks for your Venmo. Says Penny is free. Next up, Karen Reed. Thank you. Lisa, thank you for the Venmo. Says, thanks for streaming. Great verdict. Lynn says, I don't know if Lynn said anything, but she was just thanking me. So thank you, Lynn, who didn't say anything. And also, Lisa, thank you. And I thanked Marie earlier. You guys are unbelievable. Let's see if I want to see the reaction, because now we know that the camera was in court all day. They didn't broadcast it live. Maybe they'll drop the footage later, but we couldn't wait for that. We had to hear it live. Hallelujah. That should be on our Penny McGee playlist. That should be the first song. Which version do you want? Do you want the Leonard Cohen version? Which version do you want of Hallelujah? I cannot believe that we got to share this together, that we got to shout about this together, and that you were interested in hearing about it. Mark says, local here, Melanie, was awesome seeing your reaction. Thanks for covering. Go get a nice coffee. You earned it. I got it right here. I want to see them. I want to see them cover the verdict live, because we didn't see that part. Because by the time I figured it out, because I was so far behind in the super chats that I didn't know that they were live streaming it. Not really live streaming it. I'm sure it was on delay, because there was the cameraman. There was a pool camera in the courtroom, but they didn't see fit to broadcast the closing arguments. You know what they were doing on Court TV this morning? Opening statements in a baby murder trial.
With 3 networks.
Because that's apparently what they think their viewers want to see. And no, I'm not going to cover that infant murder case, because I'm not interested in it. I'm interested in this.
Welcome back to Court TV Live. Let's get you back into that Tennessee courtroom where it is day 1 of the baby.
Yeah, okay. Yeah, the baby murder trial.
Is facing murder.
Really, this is what we want to see. The Tennessee mom accused of killing her baby. Does anybody give a duck about that? Because I don't. Yes, I saw this yesterday in the Post, in the New York Post. Callie Sandy says Daniel Penny gets hired by Anderson Horowitz. Yeah, this happened yesterday, actually. The New York Post covered it yesterday. Daniel Penny got an amazing job offer. And so there's that. Tata T says, I think this is good for Karen, because now people will really see how easy it is to really falsely accuse someone. Yeah. And in this case, like the medical examiner said, Penny McGee was in the room with Andy Savitz when he died and when his body was found, Karen Reed was nowhere near Officer John O'Keefe's body when it was found. And there is no evidence that John O'Keefe was hit by a car. It just doesn't exist because it just didn't happen. It just didn't happen. Susie became a new member. Welcome. Wonder how the ME feels, says Calico26. I don't know if I'd want to be Rebecca Dedrick today because in his closing argument, and I thought that it was such a classy thing for Larry Tipton to do, such a classy thing, that he did not throw Zuzzy under the bus. He did not throw the brother-in-law, Jonathan Savitz, under the bus. He did not disparage any of them. And he could have. And another less nuanced, classy attorney would have likely done that. Crying tears of joy, Jackie says for Penny. He didn't do that. He said, this is on the medical examiner because everyone relied on the medical examiner's findings. And what a great day. Thank you, Mark. We covered that earlier. Callie Sandy, covered that. So happy for Penny McGee, says Jen. I agree. Amy's positive pathways. Thanks for the 5. This was an important case and would never known about it without you. This should have also been national news, especially with Judge Cannone as a judge. I mean, that's why I couldn't believe, Amy, that no local stations covered this at all. That's what you guys told me, right? It wasn't on Boston 10, Boston 25, whatever your local stations are there. Nobody covered it. Thank you, Leslie. Thank you, Leslie, for thanking me. Nurse Jones in the house. Nurse Jones in the house. Looks like we have a new filing on Karen Reed. Looks like there's probably going to be a few, maybe there may be a few today because of tomorrow's hearing. We're going to cover that live. Thank you, Allie. So make sure that you have hit the subscribe button down below. Make sure that you have hit all notifications. Make sure notifications are set on your phone. Make sure that you do all the YouTube things that YouTube likes. Make sure you share this stream out. Make sure that everyone sees this who needs to. Shout it from the rooftops if you have to. Deanne says, praise be, Judge Bev just floored me. She got it right. So happy for Penny. So happy for Penny. Not guilty on all charges. Penny McGee is free. Thank you all for watching this with me. Thank you for caring enough about it. Thank you for being here with me. Thank you to my moderators who kept it so classy this entire time. Even though, Norfolk County is not always the easiest county to cover, but we did it anyway because we didn't care. Scott McGinnis says mainstream media was around here crickets, as if they knew this case was a loser. Covering it at all would have made Marcy look bad. I don't know. Gem Girl says the fact that this case is on the heels of Karen Reed trials is a surprise. No one covered it, showing the insanity of these trials. Right. Yes, I don't want to cover the baby murder. All right, you guys. Stay cool, stay kind, stay classy. As I always say, moderators, you're the greatest. I love you. I love all of my channel members with all of my heart. Viewers, replay viewers, smash the like button. This story needs to be shared. Finally, something good. It's the trifecta of acquittals that we've covered together, starting with Brian Camp and then Danielle Penny and now Penny McGee. Hallelujah by Katie Lang, says Dennis the Menace. Stay cool, stay kind, stay classy. You can do it. I know you can do it. Peace. I'll probably see you later on today with some more Karen Reed stuff because who knows what's going to drop. You never know when the droppings are coming. Stay safe out there, my friends. Thank you so much for sharing this moment with me.